We'll go on the record in People versus Angel Harem, file number 255417. I get counsel put your appearances on.
Sierra Cook on behalf of the people.
Thank you, Your Honor. Richard Church on behalf of Miss Harabuk. Thank you, Your Honor. This file has been adjourned a few times as we're waiting for some companion cases in Otsego to work their way through. We have tendered our pleas in Otsego, and I believe we're set for sentencing at the beginning of October. I think I received the notices today, but don't quote me on that. And I think from talking to the prosecutor, she wants to wait to the sentencing dates to see what happens. So I would suggest probably mid-month in October, because that will put us past the Otsego motion day, which I suspect will be a Thursday.
Ms. Coke.
That is true. She entered a plea of delivery of methamphetamine on 9/5. I confirmed that with the Otsego County Prosecutor's Office. They did not have the sentence date. I checked with them as of this morning. So we just asked for a 30-day adjournment.
Ms. Harriman, have you had a chance to talk to Mr. Church about this? Do you have any objection to waiting to go further on this case until then?
No.
So we'll set this for a plea status conference hearing on the mid-October motion day.
Just to make a clear record, she pled to a delivery there as well as a second count of possession.
Okay. Thank you, Ms. Coke. Further.
No.
Thank you, Ms. Harriman. That's all for today. People versus Steven Gildner.
Sierra Cook on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of defendant Steven Gildner. Yes, he's in the box.
Sir, you come over here to the podium, please. Thompson, how did we want to proceed in this matter?
Your Honor, there is a plea offer. The updated plea offer is that Mr. Gildner pled guilty to count 1. The prosecutor will dismiss the additional counts in the first time in the habitual offender status. I've discussed that offer with Mr. Gildner. He's indicating he wants to reject that offer and go to trial.
Okay, Ms. Coke, is that a correct statement of the offer?
It is a correct statement of the offer.
All right, so Mr. Gildner, you wanted to proceed with trial in your case?
Yes, sir.
Okay. Ms. Coke, how much time do the people need to be ready for a trial?
We just got the additional labs back from the Michigan State Police Crime Lab last week. I think we can be prepared in 30 days. I anticipate this being a 2-day trial, given the number of charges and some of the lab testimony.
Mr. Thompson, how far out would you like the court to set the trial?
I did just recently get some lab results that are technical, so I would ask for a reasonable amount of time to be able to review those instead of trying to get that evidence. So I could ask for 60 days.
And would you agree with 2 days as a duration?
Yeah, that's appropriate.
We'll set it for a 2-day jury trial, about 60 days out. I will set it for a final status conference on the motion day prior to the trial date. That will be the plea cutoff. So Mr. Thompson and Mr. Gildner, to the extent that you would want to consider any additional or different plea offers, the final conference would be the last date for that. Ms. Coke, are you anticipating any motion practice?
That is possible. I need to do some research into Mr. Gildner's criminal history, which is fairly extensive. So I will get those done as soon as possible.
Okay, Mr. Thompson, any motions you're anticipating?
I'm not anticipating any motions. I would ask the court to include a motion cut off for that to include any possible, 404B or 608 evidence if that's what she's referring to.
Okay, so the final status conference will be the plea and motion cutoff. So any motions would need to be filed and set for a hearing no later than the date of that final conference. Ms. Koch, any other dates I can address for your side today?
No.
Mr. Thompson?
I guess my only question, I would be looking to, I may be looking to ask for a lesser included charge on this. Does the court require that by motion, or is that sort of handled at trial?
I think we would talk about that as part of the final instructions.
Okay.
So, yeah, I don't think that's something we need to.
All right, so you don't require a separate motion. All right, thank you.
All right, Mr. Gildner, do you have any questions about how we're going to go forward with your case?
I'm kind of confused anyways, but yeah,
Make sure that you talk to Mr. Thompson. He's your attorney. He can answer any questions that you have, okay?
I think there's been a lack of communication. But, yeah. Should I address that, what happened back there in that salary now, or?
Got nothing to do with the case.
Oh, it does to me, maybe nobody addressing it. I had a fork on me, or spoon, and person that was running the deal had a road cop come in. She sexually touched me in my private stuff. You know?
The jail
Well,
probably has a process for making complaints, so I
Yeah,
would,
well, ain't nobody done nothing about it. I keep telling people and they ain't done nothing, so I just put it out here on the table. It's embarrassing, humiliating,
all right.
and every time I've asked the sheriff to do something, he's put it off. I mean, my dog got poisoned out there and stuff. And I'm fed up with everything here.
All right, the only thing I can recommend that you do is file a complaint with the jail, and I believe they have a process for that. Okay, that's all for this hearing today. Thank you.
Thank you, Aaron. Yeah, go back with.
Sir, what's your name? I'm sorry, what that? Mr. Wood, okay. People versus Dennis Woods. This is file number 235201. And Mr. Wood, you can come to the podium there. We're on the record in this file today. I believe Mr. Woods was apprehended on a bench warrant late last week. The court set this for a bond hearing and status conference today because I believe his bond was revoked as part of that failure to appear. Mr. Vernon, have you had an opportunity to speak with Mr. Woods?
So I was notified of this hearing this morning. I had an opportunity to speak with Mr. Woods just before this hearing. I would ask the court to adjourn the status conference, but I think we're ready to proceed on the bond hearing.
Okay. Ms. Koch, do you have any objection to court setting this for status conference at a later date after Mr. Vernon's had adequate opportunity to speak with his client?
No.
Vernon, when would you like the court to set that? I mean, I could get it within 2 weeks.
Yeah.
Okay.
Yes, please.
So the court will set this for a status conference on its full motion day, October. In terms of bond, Ms. Koch, people have their comments.
Your Honor, he failed to appear in November of 2023. He had tried to enter a plea in October of 2023. He also had a probation violation in Oakland County that he failed to appear for. So a bench warrant was issued. His criminal history is 2006 weapons firearm, 2008 disorderly, 2008 aggravated domestic violence, 2011 possession pled down to use, 2011 trespass disorderly, 2015 misdemeanor false report of a misdemeanor, 2016 felony aggravated domestic, 2017 retail fraud first degree, 2022 fleet elude third degree, vehicle code and RNO. And then there's a couple of things that have charge segments, 3 of them that don't have judicial segments. So he has pretty substantial criminal history and he's been on absconded for 2 years. I would ask for a high cash bond.
Thank you, Mr. Vernon.
And my client is capable of posting a bond, but what we would ask for is a 5,000, 10% bond. I don't have the paperwork on a prior revocation. Looks like this was signed by the court on the order revoking bond and remaining last week. It doesn't look like there was a revocation of his bond until then. So it doesn't, again, doesn't appear from the paperwork I have that he had absconded anything prior to last week. Mr. Woods has appeared for all of his hearings prior to that. I don't consider him to be a flight risk. He wants to get this resolved. Since this offense occurred back in 2022, he's had 2 children. He's a family man. He's working. He's providing for that family. I don't consider him to be a flight risk. I don't think that the likelihood of conviction on this matter, based on the limited conversations that I've had with him, it sounds like there are several defenses to it. I would say that the likelihood of conviction isn't very high. So we would ask the court to consider a reasonable cash bond. We would ask that we would encourage the court to consider that 5,000, 10% would be a reasonable cash bond in this matter, along with whatever other conditions the court puts on. Mr. Woods.
Okay. All right. I did have a chance to review the file. It does look like the original bench warrant that was issued in November of 2023 does indicate that his bond was revoked at that time. Although my order of last week also indicated that.
I don't have a copy of that.
Yeah, no, so looking at the underlying charges, we have some serious charges, including 3rd-degree fleeing, which is a 5-year felony. Mr. Woods' charge is a habitual 4th offender, which would make that maximum life offense. So we have a significant penalty. Mr. Woods does not appear to have any ties to this community. He's got a downstate address. His previous bond was $10,000, 10%. Mr. Woods has been missing for almost 2 years now. So looking at all of those factors, the court finds that cash or surety bond in an amount higher than what the previous bond was, because that didn't ensure his appearance is necessary to, particularly for the purpose of ensuring his appearance at the next hearing. The court will set bond in the amount of $25,000 cash or surety. And again, we'll set this for next hearing date in about 2 weeks on the court's full motion date in October. The court will impose all the standard terms and conditions of bond that were previously imposed. Ms. Koch, anything further that we need to address here today?
No, thank you.
So the only thing I would ask is that an amended complaint be issued. It appears on the information, the complaint that I have, that under count 1, it fails to identify the penalties associated with that count 1. My information shows that it stops here. It doesn't identify the felony language.
Yeah,
my count 1 appears to be defective, so I would ask that it be reissued or amended.
mine's it's handwritten, and so Ms. Koch probably would be appropriate for you to information.
Thank you. I'll have Ms. Hilliker do that today.
And just so I'm clear, that's a cash surety, not a 10%.
Correct.
Thank you, Your Honor.
Is Ms. Danko present?
She is.
People versus Michelle Danko, file number 255398. Ms. Danko is present in the courtroom today. We're here today on some alleged probation violations. This is set for a show cause arraignment. Mr. Thompson, you had an opportunity to speak to Ms. Danko.
I did speak with her, Your Honor. I advised her of the charge. I was actually a little bit uncertain on the maximum penalty since it's multiple technical violations being asserted at the same time. But we did discuss her right to a hearing and her right to counsel.
Okay. Mr. McFaldo, would this be a first violation? Are we looking at a 15-day maximum penalty?
Oh, Judge, there's 5 counts, so that would be That would be the, 4 or more is the maximum penalty.
Okay, gotcha. So the 1 year on her, is it a 1 year on her underlying charge? Attempted aggravated?
2.5 years, Judge.
Okay, so Ms. Danko, you've had an opportunity to speak with Mr. Thompson, is that correct?
Yeah.
Okay, and so he's advised you of your rights. I need to advise you that if you're found guilty of any of these alleged violations, that it could subject you to the maximum penalty on your underlying charge, which is the attempted stalking charge. And that would be up to 2.5 years. Do you understand that?
Yeah, I thought it was 60 days.
She's
Well-
confused, Judge, because you held 60 days in jail in advance.
Yeah, so I think that's potential exposure under the original sentence order, but I don't want to concede that it's the potential maximum, but that's what they're alleging.
Okay. How does Ms. Danko want to plead to these violations?
She's asking for a hearing. She's pleading not guilty.
So Ms. Danko, I'm going to enter a not guilty plea on your behalf, okay? And we'll set this matter for a hearing. You'll be notified of the date and time of that hearing. It's important that you stay in touch. Mr. Thompson, have you been appointed on this case?
I will be, yes.
So make sure that you stay in touch with Mr. Thompson, okay? And then, does she need to report or do anything with you today, Mr. Thompson?
I see you Wednesday. Yeah, I'll see her Wednesday.
Make sure you're back to see Mr. McDowell on Wednesday, okay? And then we'll set this for a hearing. Mr. Thompson, is there any kind of date that you would like to request or interval?
No, you're
We would ask for it as soon as possible. If the court recalls, she was sentenced on 7/10/25. There was a recommendation of 60 days in jail. The court felt that she was a victim in the case, but told her they're giving her no upfront jail. 60 days would be held in abeyance, and if she violates probation, she would go straight to jail. The quote was "do not pass go" with no hearing. So I would ask to move forward. These violations started just a week or two later after the court gave her that break.
Okay, so we'll set this for a hearing on the court's full motion day in October, so in about 2 weeks. At that time, in terms of bond pending that hearing, Mr. McDowell.
Judge, I don't have a problem with the PR bond check. I've been seeing Ms. Danko regularly. I'll see her again Wednesday.
Okay, so this will be a PR bond, so Ms. Danko, you don't have to post any money, but you do need to continue to comply with your probation and to make sure that you stay in touch with Mr. McDowell, and that you appear at that next hearing, okay?
Okay.
Do you have any questions about that? Anything else we need to address in this file?
No, Judge.
Mr. Thompson?
No.
Thank you, Ms. Danko, that's all. Let's call that. We'll call the case of People versus Harris. This is file number 255452. Was set for 2 o'clock.
There was a H1 for today's date.
Okay. Yep, it does look like that was properly served. I do not see anybody connecting at all. Mr. Harris or the facility where he's at? Have you been able to have any kind of contact, Mr. Gurney?
So I have, I had a conversation with Mr. Harris, Your Honor, Adam Vernon with Mr. Harris. We had to have them call us,
Okay,
because they had to arrange a private conversation, so I'm not sure what their process is for connecting to the court. But I did have a conversation with him, and I did have a conversation with the prosecutor about entering a plea. I still have questions about whether, because he's lodged in Arizona on charges and the delay between those offenses and these, whether any penalties here would mandate consecutive sentencing or not. So we're still working on those things.
okay.
But why he's not here, I don't know.
I think for purposes of today's hearing, I mean, we're 6 minutes past the time. It's like, and you have hearings continuing up until 3:45.
I do.
So if they somehow appear and sign in, then we can try and go forward with the case. If not, then I will reschedule this for its October full motion day in 2 weeks. And spoke of this, asked that you prepare another writ. Try again. Do you have any objection to that?
No, thank you.
Can you get his Arizona criminal history?
No, I have no way to do that.
We have to figure out a way to do that then.
All right, thank you. That's all for that hearing. Our next hearing set for 2:15, Ms. Leal, so we'll take a short recess. We're on the record in People versus Jennifer Leal. This is file number 255429. Clicking at council.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of the defendant, Jennifer Leal.
Okay, so we're on the record today. This is set for a hearing on defendant's motion to suppress. I did have an opportunity to review the motion and the brief along with your response, Ms. Coke. Some aware of the issue generally. Ms. Coke, did you have some witnesses that you wanted to call today?
I do. I'd like to call MDOC Officer Michael McFalda.
Do you solemnly swear or affirm that the testimony I'm about to give today shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, Mr. McDowell. If you can be seated in the witness chair, please. And once you're seated, if you can spell your first and last name for the record.
Michael McFalda, MICHELMACFALD.
Ms. Coke, proceed with your.
Mr. McFalda, on May 8th, 2025, were you supervising Jennifer Leal?
Yes.
How long have you supervised Miss Leal?
I don't have the exact date, it was sometime in 2024.
So you've been supervising her for an extended period of time?
Yes.
And what type of charge is she on probation or parole for?
She's on for meth involved charges.
Okay. Now, on May 8th, did you authorize a search of her living quarters?
Yes,
Can you tell me what happened that day?
yes, I had some information. This wheel was in possession of some methamphetamine. I sought the assistance of the sheriff's office and to look for her over in the commercial hotel area, commercial placement area. I knew previously that she'd been staying, I knew she was transient at the time, semi-homeless, and I knew there's, she was staying at times in apartment number 1.
Now, where was her address listed on her, or what address did she give you originally?
Her mother's is her, was the address, like a mailing type address. You know, many conversations, supervising this wheel for a long time. I knew she stayed there off and on, but typically she would only stay there maybe 1 or 2 days a week. But due to some conflicts with people.
And where did her mother live?
She lives in, she called it a Red Roof Inn. I'm not sure what it is.
Right here on Grayling?
Yes,
But she's only allowed to stay there 1 to 2 days a week?
that was what she reported.
By her, you mean Jennifer Leal?
Yes.
So you said she was transient. What did she tell you about that?
Well, she was removed from commercial placement there at the hotel due to some violation behavior. And after that time, I would see her on a regular basis twice a month. You know, and I knew she was staying place to place, struggling, you know, trying to find her residency.
So on May 8th, where did you look for her at?
We were at the commercial placement area.
And who is that apartment or room, who is that rented to or assigned to?
From what I knew, it was Dean Gotti. He's a federal parole.
How did you know that she was staying there?
I had contact with her there at that room prior to that. Prior 3 weeks.
Now, on May 8th, did you go into that room?
I did, yes, I did.
Okay, what happened? What happened initially?
Initially, Deputy Minnick Townsend approached the door. It was decided that they would try to make contact on their own, just not to, I don't know, to alarm anybody. Get some contact prior with Mr. Gotti and Jennifer Beal over some different matters. So he went to the room, and probably 5-10 minutes later, they come out. And I heard about what happened, and I went into the room.
So were you present or near the extended stay apartment 1 when they entered?
I was around the corner out of sight.
But you knew that was their plan and you had authorized that?
Yes.
When you entered the apartment, did you see any of Miss Leo's stuff in the apartment?
Yes, I've seen a lot of her personal items there. Medications.
Are you familiar with her stuff from previous parole searches?
Yes,
And did it appear that all of her stuff was in this apartment?
it appeared that the things that she typically has in her possession was there.
Okay. And did you talk to Mr. Godding that day about whether or not she had been staying there?
I don't remember.
During that search, were there any narcotics located in the residence?
Yes, that's better.
Where was it found?
I'm hearing this from the deputies there. They found some in the bathroom, and I believe there's some more on the nightstand or table area inside. It's a small room.
Was one of her parole conditions the search of her home residence and her persons?
Yes.
And she agreed to that?
Yes.
I have no further questions for Agent McFalda.
Dr. Thompson. Thank you, Aaron. Agent McFalda, you said that at one point Jennifer's address was at the commercial placement.
Yes.
Is that the same Red Roof Inn?
No, it's a state extended stay.
Okay, the extended stay. All right. So there was a time that Jennifer resided at that extended stay that she was told she could no longer reside there.
Right.
Do you know approximately when that occurred?
I don't have that.
Okay, it was before May 8th of 2025. Okay. So after that, she used her mother's address as her residence for purposes with you?
Yes.
Okay. You indicated, though, your understanding was that she was somewhat transient?
Yes.
All right. Did she have to stay in a mental hospital for a period of time?
I would have to know. I don't remember.
Okay. Do you recall if she had just recently been released from that mental hospital?
I don't, now that I'm thinking, she did, she was in the hospital at some point. I don't remember the exact timeline.
When you believe a parolee is transient, how many residences do they have for and anywhere they stay? Okay, so for purposes of Miss Leal, on May 8th, 2025, what was her residence? Did she have one or did she have more?
I'll see. I believe she had, her mother's residence and then the other places that she stayed.
Okay.
Extended stay.
And so hypothetically, a few nights later, she stayed with a different friend overnight, would that also then become her residence?
She usually reported to me where she was staying on the night, so if she reported to me firsthand knowledge that that was the spot that she had stayed before.
Okay. In your mind, when you are assessing what somebody's residence is there a minimum length of stay, or as soon as they spend the night there, essentially, does that become their residence?
They spend the night there, let's say, there.
Okay. And you did cite in response to Ms. Coke's questions that you observed clothing, medication, and toiletries at this apartment being built, correct?
Yes.
And you believe those are Ms. Leal's? And you would agree that a business traveler at a hotel might have clothing, medication, and toiletries with them? Would you agree with that? Wouldn't necessarily make that hotel his residence for that individual.
They're on parole, they're staying in a hotel. I consider that.
If it was one night, or is there some sort of amount of time that you're looking for?
I guess it's hard to answer that.
And
more information. By me, if somebody on parole said, this is where I'm staying for the next week, so I have nowhere else to go, I have to stay with the residents.
You would or would?
I would.
Would, okay. On or around May 8th, 2025, did you ask Miss Leal how long she had been or was going to stay at this apartment?
Not that I.
When did Miss Leal identify this apartment as her residence to you before May 8th of 2025?
Yeah, I had contacted her at that place prior. She reported to me, what the exact date, but that was a place she had known, so she would stay there.
So she reported that she had stayed there.
Correct.
Okay. She probably didn't use the words, this is my residence.
That's it.
As far as her paperwork, maybe she regarded her mother's home as her residence, didn't she?
Or that's her, considered her, that's her address, currently her kind of stable area where she could always have inside of somebody to get a hold of her through. That's how I understood it.
Yeah. And she, even when she was transient, she intended to return to her mother's house. Was your understanding?
She would have liked to return there, right?
Yeah. Okay. You indicated that Miss Leal was subject to search at her residence as well as her person. Is that correct?
Yes.
All right. Would you agree with me that this search did not generate anything from searching her person?
Yeah, no.
So the question for the court today is whether the police had a right to search this apartment. Do you agree with that, generally? Motion. All right. Thank you. How many further questions?
Just to be clear, the extended stay hotel, which is the 78 I-75 business loop, is that like a regular place you can stay for a night, or are the people placed there?
I know there are people that live there that are not supervised by the Department of Corrections. I don't know if it's a nightly place where you can stay. I feel like it's more of a housing. Housing area.
So it's a more of a long-term place in your mind?
Yeah, I wouldn't consider it not a hotel per se.
And you don't recall how, you said it was a couple of weeks prior that you had had contact with her at that residence? At Mr. Gooding's?
Yeah, I would estimate it was within, a 3-week period prior.
And on May 8th, she was there?
She was.
And just to clarify, you said she'd like to go back to her mom's at the Red Roof Inn, the place she uses as her mailing address, but she's not allowed to?
Correct.
No further questions.
No, thank you.
Mr. McFell, I've got some questions. It wasn't clear to me, this deal on supervising her on probation. She doesn't on parole. I'm familiar with the standard provision of probation that allows for the search. Reads, you must submit to a search for your personal property, including but not limited to your vehicle, residence, computer, without need of a warrant, if the agent has reasonable cause to believe that items violate conditions of your probation. Is that the same term that she was subject to as part of her parole?
No, it's a different condition. Because we haven't put the word right in front of me, but it's condition 4.2. 4.2. Must submit to a search.
We got a note for the record, Mr. Haven, you can.
Yeah, I'm sorry. I'll just object to that part of the court record.
Yeah, so I'm gonna strike that comment and testimony related to that. So Mr. McFell, I mean, condition of parole.
Yes.
Is that right? Is that something that you went through with Ms. Leal at the time she was?
They are signing your goal order. How I can follow orientation.
Ms. Koch, I would like to see a copy of that condition. I don't know that it necessarily needs to be the exact one signed by Ms. Leal.
You, Can I check? I'm looking through Mr. McFalda's stuff, but I wanted to see if he had her.
If you want to step down.
I won't have it right here. I have to go to my office.
Okay. Can you do that while we're going forward with testimony, and then I'll recall you on that issue? Okay. So, for the record, the court's excusing Mr. McFalda for the moment, for the witness stand. We'll pick up further testimony from him in a moment. Ms. Koch, do you have other witnesses that you wish to call?
Yes, the people would like to call Deputy Anthony Minnick.
Do you solemnly swear or affirm that the testimony about to give today shall be the truth, the whole, truth, nothing but the truth, so help you God?
Yes, I do. Okay, Deputy, if you could be seated in the witness chair, and please state your first and last name as spelled for the record.
Deputy Anthony Minnick, Anthony Anthony, Minnick, Minnich.
Ms. Koch.
Deputy Minnick, where are you employed?
Crawford County Sheriff's Department.
On May 8th, 2025, did you accompany Mr. McFalda to do something?
Yes, I did.
Can you tell the court what you accompanied him to do?
A parole search for two subjects, one of them being Jennifer Lee.
And did you make contact with Jennifer Leal?
I did.
Where did you make contact with her at?
The Greenlee Extended Stay Apartment 1, which is 78 I-75 Business Loop, Greenlee Township, Crawford County, State of Michigan.
Can you explain how you made contact with her?
Of course, after briefing with Probation Parole Officer McFalda, Deputy Jacob Townsend and I approached, we're advised to be Jennifer Leal's residence at the Greenlee Extended Stay Apartment 1. Deputy Townsend and I, we knocked at the front door. We observed a woman open up the like the window curtains and kind of look at us. We advised her to come outside. It's probably about 25 seconds, about 25-second delay. And then Jennifer ended up opening the door, and we had her exit the residence there.
And what happened when you entered that residence?
Deputy Townsend had stayed with Jennifer while I went inside and made contact with Dean Gaudy, which was, he was in the bathroom.
And what happened after that?
I advised Dean to step out of the bathroom. At this point, he kind of was probably taking a shower. He was wrapped with a towel, and he wasn't coming out of the bathroom. So I had just asked him, is it yours or hers, referring to Jennifer Leal? He stated it's hers. I advised her a couple more times to step out of the bathroom. He ended up going back towards the toilet, at which point I tried stopping him. He ended up getting the toilet flush at myself, and at that point, Deputy Townsend ended up taking Dean down to the grounds, arresting him and locating some methamphetamine in that immediate area, as well as another area inside the residence.
Okay. Just to be clear for the record, Miss Leal, where was she at during this time?
So we had her step outside, so she was just outside the main doorway of the residence apartment there.
All right. And where did you locate methamphetamine in the apartment?
So two separate places, right next, like to the right, if you're looking at the toilet, it'd be right to the right of the toilet bowl there was a small amount of methamphetamine. I think it was like just under a gram, as well as a pipe, around 15 syringes. And then outside of the bathroom, which the apartment is they're very small. There's a cabinet, would have been on the east wall there. On that cabinet was also a baggie that had just under 1.5 grams of methamphetamine.
Did you make note of the contents of about how big is the apartment?
400 square feet.
Besides the bathroom, is the rest of the apartment open?
Wide open, yes.
It's a 1-bedroom apartment?
The 1 bedroom, as well as it's got like a little kitchenette area in there.
Did you make note of what the contents of that apartment were in terms of clothing, etc.?
Yes, I did.
Can you tell me what you noticed?
So in the bathroom there, I had a medicine cabinet, which had both of Dean Godding's and Jennifer Leal's name prescription medication. There was also a bra inside the bathroom, which is suggested to be female. There was also, while speaking with Dean Gotti, he showed me kind of the living arrangements, and in the open area, kind of where they slept on the pull-out couch, it was a place where one would hang clothing. And Dean had estimated about 60% of the clothes that were hanging up belonged to Jennifer. The other 40%, give or take, were his. And then there's also a spare set of keys that Dean Gotti had stated were Jennifer's spare set.
So on Miss Leal's keys was a key to that room?
Yes.
Now, do you have any dates that officers had made contact with her before?
Yeah, I was advised that April 24th of 2025. Volunteer McFall, as well as Sergeant Swope, had was trying to make contact with Miss Leal there, and they went to the Grandview Senate State Apartment 1, and they made contact with both subjects that were staying.
And that was Jennifer Leal on April 24th at that apartment.
Yes, and Dean Gotti.
Did you speak to Dean Gotti about how long she had been residing in that apartment with him?
Yeah, I did.
What did he say?
I believe he said it was only 1 or 2 weeks, and had asked about getting her out, which we explained to him kind of the eviction process.
Your Honor, I'm going to object to the hearsay nature of that response.
And we're here on a suppression hearing. I think he's explaining what Mr. Gotti was telling him at the time. And so that would fall under present sense impression.
Your Honor, I'm specifically objecting to that because it's a historical, recount of how long she's supposedly been there. When the officer is testifying about objects, I understand that that's, more about seeing things and less about claiming prior facts, but I think this is squarely hearsay, and I don't think any exceptions apply.
So to the extent that it's being offered to prove the truth of the matter, in other words, that she did actually stay there for a week or 2 weeks, then I will sustain the objection.
Thank you, Your Honor.
Do you have any personal knowledge of her having been there before? And you said April 24th, which was the last contact you knew of her in that residence.
On or about, yes.
Do you have any information of her being there before that?
I do not.
So you saw her, just to recap, her clothing was hanging up in the closet. Her medications were, did you say in the bathroom, in the mirror? Is that what you said?
She had, it wasn't a closet, it was the open area, but it was almost like a hanging rack. And the medication was in the medicine cabinet in the bathroom, as well as the cabinet in the living area. Both subjects had medication with their names in both those locations.
And she had a key for the room on her key ring.
Yes.
Okay, I have no further questions for Deputy Minnick.
In terms of the key that you're alleging that Ms. Leal had to the apartment, do you recall if it was with her other key or if it was separate?
I can recall that Dean stated he was looking for his keys, and he found a set of keys. He said this is something to the effect of, this is my spare set that Jen's been using. And then he retrieved one of the keys to give to a pastor at a local church so he could come take care of the cats.
Okay, so Ms. Leal didn't have keys when you entered the apartment.
Not on her, they were on, those keys in reference, which Mr. Gowling had stated were a spare set that she had, were on, I believe, a cabinet or like the kitchenette area.
So your only reason to tie that spare set of keys to Ms. Leal is what Mr. Gotti told you that. I'd object to considering those statements.
At this point, he's talking about what Mr. Gotti is telling him right now. These are the keys that Jennifer uses. I think that clearly falls under present sense impression because he's saying that these are hers right now.
Again, to the extent that those statements of Mr. Gotti are being offered for the truth, the
You indicated that you found methamphetamine in the bathroom as well as, I think you said a cabinet on the east wall.
Yeah, it was on top of, I believe, like this cabinet, by like the kitchen area.
So like in plain view or hidden away?
It was on top, obviously you'd have to like, without manipulating anything, you could see it in plain view if you're looking for it. But we were going through, moving stuff, but that's where it was located.
Was it like high up and hard to reach?
No, no, it is, a cabinet probably, with the top shelf, I'd say maybe 3.5 feet off the ground.
Okay. And you observed it lying on top
Yes.
in plain view?
Right.
You said that was on the east wall of the apartment?
So with the position of how the wall is, because the rooms, if you think of a square and then another little square in the, northeast corner, it would have been on the east side of that wall.
And that's in the open room of the
Yes.
apartment? Is it a larger container or just like a small?
I believe a small plastic bag.
How many further questions? Thank you.
Ms. Coker, any follow-up?
None for Deputy Minute.
Thank you, Deputy. Just sit down. Take the witness stand, Mr. McDowell. I'll just remind you, you're still under oath. My previous question was, I was looking for the wording of the condition that this legal sign would allow for the search of residence.
Control order condition 4.2, written consent to search of the employee's person and or property. MCL 791.236 subsection 18. I voluntarily consent to a search of my person and property on demand by a peace officer or parole officer. If I do not sign, I understand my parole may be rescinded or revoked. Signed by a parole board or I should.
Okay, and you testified that this legal sign, parole form reflecting on signature.
I have a reinstatement because I had the extender parole with her signature on it. With those conditions.
Okay.
Sometimes the original parole order don't always make it to the parole office, but they are signing there in prison.
Ms. Coker, any follow-up to my questions?
If she had not signed that, would she have been released on parole? So she had the option to not sign it. She chose to sign that.
That's my understanding, correct? For that condition. Parole order. Yeah,
Thank you. No further questions.
Mr. Thompson?
No further questions. Thank you.
Thank you, Mr. McDowell. You can step down. Ms. Coker, do you have any additional witnesses?
No, Your Honor.
Mr. Thompson, any witnesses?
No, Your Honor.
So, anything you'd like to say for argument?
Your Honor, Ms. Leal used her mother's address as a mailing address, but she was not allowed to live there based on her own statements to the probation parole officer. She was staying with Mr. Gooding. They had made contact with her there on April 24th. They made contact with her again there on May 8th, the date of this search and seizure. She was present at the property. Mr. McFaul indicated all of her clothes that he knows or her possessions that he knows her to travel with and have with her were present. Her clothing were hanging up. Her medications were in various places. So I'm not sure, Ms. Leal doesn't have another residence to be searched. This is where all of her items were, and this is where she was. I would ask the court to find that this was a proper search. Thank you.
Thank you, Your Honor. Respectfully, I would disagree with the prosecution for position. It seems to be that an individual's residence is where they stay, even for a single night. I don't believe that's consistent with any definition of residence. I don't believe they established in any way that Ms. Leal had a property interest in that property, whether by ownership or lease. I don't think they've established that at all. So I don't know. I don't believe that they qualify for that exception to the Fourth Amendment that applies to parolees in terms of their person residence. I don't believe they've had either required that. Prosecution.
Thank you. Again, I did have a chance to review the written briefs. I listened carefully to the testimony that was given here today as part of this motion. On motions to suppress evidence or the admissibility of evidence, whether or not to suppress or admit evidence is a matter that's within the discretion of the court. The court's acting within the exercise of its discretion. Ruling out this motion. I think as the parties have identified, the issue here is whether or not the place that was searched, where the contraband was found, was a place that police or Mr. McCall would have been allowed to search based on her parole conditions. And the evidence in this case, I think establishes, well, first of all, I think the argument that Mr. Thompson is making is that Miss Leo, if she was staying there on a temporary basis, and that temporary place where you're staying can't be considered a residence for purposes of searches under a parole condition. I think you have to look at the context and the overall facts of the situation. If Miss Leo was regularly staying at her mother's house, if there was evidence that that was her permanent residence that she was at most of the time, as a reasonable person would look at it, maybe staying at a hotel for a night or 2 nights or a week or even 2 weeks could be considered to not be a residence at that point. Just the same way that if a person has a home in Grayling and they travel up to the Upper Peninsula or Mackinac Island for a vacation and they spend a week in a rental or at a hotel, that place doesn't become their residence necessarily. I think if you have a situation, which is what we have here, where Miss Leo doesn't really have a residence, regardless of whatever address she gave, where she's couch surfing, for lack of a better term, that's a completely different situation than the one I just described when someone's on vacation or staying with a friend or so forth. I think this really is one of those circumstances where, because of Miss Leo's housing and security issues, that wherever she was staying at any given night was really her residence. And it was temporary by the very nature of the way that she was living, at least at that time. So I don't think, looking at this from the standpoint of reasonability on behalf of Mr. McFalda in terms of searching her place, I think he had a reasonable expectation or reasonable belief that that's where she was living. I think that's backed up by the evidence that was presented in terms of the testimony. Her Miss Leo's clothes were there. She had medications there. They were in a medicine cabinet. There were toiletries belonging to her there. And there was testimony that, given past experience with Miss Leo, that everything that was in that room is typically everything that she would have had with her. And I think all of that lends itself to a finding that that hotel room wasn't any more or less permanent than any other place that Miss Leo was staying at or residing at the time. So, looking at the evidence as a whole, again, in context, I think there certainly was reasonable belief, proper cause for the search of that location as a residence of Miss Leo at that time. So the court will deny the motion to suppress. Ms. Koch, I believe you provided an order for the court to sign, so I'll sign the order. Just reflecting for the reasons stated on the record of motions tonight. So that leaves us with our status conference for today. Mr. Constant, how did you want to proceed in light of the court's ruling?
Did review this potential ruling with my client. She indicated to me that denied the motion. She still wanted to exercise her right to trial in this matter. I may be seeking reassignment in this case. Ms. Leo has indicated to me she's objecting to potential conflicts of interest inherent in my representation, both because of my representation of her daughter in a probate court minor guardianship case. I don't believe there's been any actual adversity in that file, but it would be potentially adverse. In addition, my law partner represents two individuals who are charged with crimes in which Ms. Leo is noted as a potential witness in both of those cases. We have used an internal screen, so no confidential information has been exchanged with my law partner, but Ms. Leo has objected that it creates an appearance of impropriety. So I will be seeking into assignment on this. We're going to have to go outside the contract to do that. So that may delay her trial, Your Honor. But I think for purposes of the trial, it's important to well, I will be seeking that reassignment for the trial. Thank you.
All right, what I'm gonna do then, Ms. Leo, is we're gonna set the timeline for the trial, get the trial dates out, and then I'll build in enough time. You're gonna have a new attorney for that attorney to meet with you and come up to speed on your case so that you and your new attorney are ready for trial when it's time.
Okay.
So, Ms. Coe, do the people need any particular period of time outside of what I just described to be ready for a trial?
Your Honor, I'm gonna file some type of 404B and possible 609 notices. Ms. Leela has 1, 2, 3, 5 methamphetamine cases, convictions in the last 7 years. I need to do some research on those for the for any 404B information. And she has a contraband to the jail, and I need to research whether that qualifies as a theft or dishonesty. So I just need about 30 to 45 days.
All right, I'm gonna set trial out at 90 days, so it sounds like that's plenty of time for you to be ready.
Thank you.
Okay, and how many days of trial do you think we would need?
1.
Mr. Thompson, in terms of the timing, you have a projection?
No, I would generally agree with that time estimate, Your Honor. And I believe the court's proposed trial date is reasonable time. So let us get counsel set up. Thank you.
Okay, so we'll set it for a 1-day jury trial at 90 days out. I will set it for a final status conference on the motion day immediately prior to the trial date. That'll be the plea cutoff and the motion cutoff. And so, Ms. Leo, once you have new counsel assigned, just make sure that you stay in touch with your attorney. Do you have a good address that you send notices to Ms. Leo?
I'm at my mother's. I'm there.
You get your mail there?
Yeah, and I've been going there.
Okay. So if we send mail to that address, you will get it.
Yes,
Okay.
definitely. I will get it.
Just the address we have her as the 758 North I-75.
No, it's 107 Clare Street, apartment 12.
Okay, so that's what we'll send our communications. And go forward based on that schedule. Ms. Koch, anything further we need to address for your side today?
No, I'm going to be doing a writ for Mr. Gooding at the trial, but we'll deal with those logistical issues when we get there.
Okay. Mr. Thompson.
Nothing further for today's record. Thank you.
Thank you. That's all for today.
We're all set. You can go. Mr. Dick is here.
Okay, we'll call People versus Raymond Matthew, file number 255454. Matthew present? Yes, sir.
James Dick on behalf of Mr. Matthew.
You're right there. Today. How do we want to proceed with this file?
At this time, Your Honor, we are requesting to set this for a jury trial. And Your Honor, the court's aware, the co-defendant's counsel is en route. He said he would be here just after the car trouble, apparently. Mr. White.
All right, so in terms of Mr. Matthew's case, let's go, how far out for trial.
You know, we can try this case and as soon as the court can get on the docket, but I'm gonna ask that it's consolidated if Mr. Matthew is going, I'm sorry, if Mr. Baumgartner and Mr. Matthew are both going to trial. It's exactly the same set of facts, so I'm gonna ask to consolidate them. I believe they're both going to trial. I think both counsel will agree that we should try them together. They were literally together when this happened.
Mr. Dick, is that something you've discussed with your client or with the?
Yeah, I would have no objection to that. I don't know with Mr. White, whether he would on behalf of Mr. Baumgard, pardon me.
Okay.
Sorry, but yeah, we have no objections from us.
All right, and do you need a particular period of time before the court sets the trial to be prepared?
I don't see more than 30 days. Meeting.
Okay. All right. I mean, I think realistically, it's gonna be about 60 days before we're able to get it set. So it sounds like that's enough time. For you. If they are tried together, Ms. Coke, how many days of trial? Do you think you-
Yeah, we ran the preliminary examination in this. It's primarily the witness testimony and some video. I would say we could do it in one day. There's not a lot of dispute here.
Mr. Dick?
Yes, I think that would be an accurate statement that it would be completed within one day. I did want to mention to the court, I have another, well, 2 other trials scheduled for, my calendar's not coming up, either November 8th through the 10th or 13th through the 15th in Mississauga. The circuit court there.
Okay. All right, if there's a conflict, just notify my office.
Yes, sir.
As soon as you get the dates. What's that? Yeah. We'll have to address that. I want to make sure they're getting together first, so we can talk about that at the final stage. I'll ask you first. Yeah. Is that what you're?
No, I'm just like wanting you to pick a jury, depending on how that was gonna go, if it was gonna affect the time that it would be trial.
I'm gonna set it for 2 anyway, just in case. If we don't need the extra day, we don't need it. But I'm gonna set it for 2 days. Is that accepted?
That's what I was asking.
So we're gonna set it for a 2-day jury trial, about 60 days out. I will set it for a final status conference. Mr. Matthew, there'll be one more hearing for the trial date. You'll get notice of the date and time of that, as well as the date of trial. To counsel, I'm gonna ask that if there's a stipulation to try them together, that everybody puts together a stipulation in order and signs that to consolidate. If there's not a stipulation, let's go.
Yes, thank you.
And that'll all need to be done prior to the date of the final status conference, which will be, again, on the full motion date immediately prior to the trial. That'll also be the motion cutoff for any other motions and the plea cutoff. So to the extent there are any further plea discussions, that plea would need to be entered no later than the date of that final status conference. All this will go out into an order that will go to the parties. Ms. Koch, are there any other scheduling matters that you have to do on this case?
No, thank you.
Mr. Dick,
Nope, all set, Your Honor, thank you.
Mr. Matthew, do you have any questions about how we're going to proceed with your case?
No, Your Honor.
All right, thank you.
Thank you.
Got it. I apologize this morning. I think there may have been a little delay in my wife also missed it covering for me in the other hearing.
Oh, this morning?
Yes,
No, it worked out
I
okay.
did. Okay, I wasn't sure if she wasn't admitted at first because it didn't have my name.
No, I
Okay.
think it was just a little bit behind.
Okay.
So,
I'm happy to hear that. Thank you.
Mr. Church, are you ready with Miss Halabuk's case?
Yes, He's out in the hallway.
Handbooks. I put them on chat. I didn't know.
All right, Ms. Halabuk, you've come up to the front, please.
Just gotta sign that. Just scan it. Just email it to Sarah.
Thank you. We'll go on the record in Ms. Halabuk with number 255402. The record should reflect itself present here in the courtroom today. This is the date and time set for sentencing. If I could have counsel put your appearance to
Sierra Cook on behalf of the people.
Thank you, Your Honor. Richard Tristram on behalf of Miss Halabuk.
Ms. Halabuk, you had an adequate opportunity to go through the pre-sentence report and talk to Mr. Tristram.
Yes.
Okay.
Your Honor, before we get started, I want to ask the court to consider an adjournment here. I reached out to the prosecutor ahead of time about a stipulation for it. She was not agreeable to it. There's really two issues here, one of which I think does legally affect the proceeding, the other not so much a legal issue, but a personal issue for Ms. Halabuk. First, we'd ask because she's in the middle of an eviction process and she's trying to get her property out of her house. She doesn't know how long she's going to have to do that. Again, I don't think that's a legal basis necessarily, but it's a personal issue that she's experiencing right now. She's trying to get her property out. So I would ask the court to consider that. Additionally, and I would point the court to page 12 of the PSI where it talks about her mental health. It doesn't identify on there some of the medication that she was on, and it also kind of identifies that the doctor wasn't willing to talk to them. I've kind of experienced the same issue with the doctor. We've reached out to try to get information about the prescriptions that she was on at the time that this offense happened. And frankly, I think Ms. Halabuk could tell the court some of that, but it doesn't have the same weight that it does coming from the doctor, I think. And again, as recently as this morning, he basically told us, no, get lost. So I'm kind of at a loss for what to do with that, but I would like to get that information for the court because I do think it has a bearing and offers some explanation to the behavior that we see.
All right, Ms. Coe.
Your Honor, Ms. Halleck presents today with 8 misdemeanors and 2 felonies. There was an offer made in this file months and months ago. She did not accept it and chose to have a jury trial, which she has the right to do. We are at sentencing because of the choices that she made. She also, since this case, has gotten a methamphetamine conviction in it says Chippewa County on the PSI, but that happened since then. So I don't know what kind of medication she was on, but it certainly looks like she was using methamphetamine based on her criminal history. Now I have 2 more cases that I've just have on my desk for retail fraud of Miss Halabuk, taking some items from a local store, as well as a no insurance. My point of this is that I don't know that she deserves any additional consideration from this court, considering the choices that she's made both before this, which you could see in her criminal history, and since this, which is included the additional methamphetamine case, the additional retail fraud case, and the additional insurance case. I think that we had a trial, which she had the right to do. We're here for sentencing, and she should be sentenced. Thank you.
Great. I would note, I don't believe that Mr. Troop certainly didn't ask for any adjournments of any of the trial dates and so forth. I think given all the circumstances here, I don't have a problem. I don't think 14 days will affect the sentencing. I think it's appropriate to give Mr. Kirsch, particularly regarding the medications, I think that should be advised of, or at the very least, should give you additional opportunity to find out what those are and to prevent more of that information. Ms. Halabuk deserves to have the court have as much information as it can prior to sentencing. So I don't have an objection to a short adjournment of 2 weeks till the court's full motion day in October. At that point, we will go forward with sentencing regardless of any other circumstances. So whatever needs to be taken care of needs to happen within the next 14 days. Further to that.
No, Your Honor, thank you.
So, all
No.
right, thank you. That's all for today.
Thank you.
Sir, can you tell me what your name is?
Travis.
He is.
Mr. Ackerman, if you come forward. All right, we'll go on the record in People versus Ackerman. This is file number 245312. The record should reflect Mr. Ackerman's present here in the courtroom today. And matter was added this morning for a hearing today at 3:15. This is Raymond on some alleged probation violations. Mr. Thompson, have you had an opportunity to go through those with Mr. Ackerman?
I did, thank you.
Mr. Ackerman, did you have a chance to talk to Mr. Thompson about the allegations?
Yes, sir.
Do you understand what the alleged probation violations are?
Yes, I did.
Mr. Thompson, did you have an opportunity to speak with Mr. Ackerman about how you want to plead today?
Yes, I believe he intends to plead not guilty to request a hearing, request court-appointed counsel. He's been screened and approved, and I would be appointed.
Okay. Were you otherwise able to advise him of his rights?
Yes, including the maximum charge for the technical and the non-technical violations.
Oh, thank you. So the court will enter a not guilty plea on your behalf, Mr. Ackerman, with regard to all three of the alleged violations in this case. The court will set this for a hearing. Mr. Rifelda, do you have any recommendations regarding filing pending that hearing?
Judge, he's on, obviously, he's on for a 10-year felony. I'd ask for a 10,000 cash surety bond, Judge. He was reporting to another county for a while, but then he, I don't know, kind of came back to the area, instructed him to come in and report to me, and he didn't fail to do so. He was arrested over the weekend, so.
Mr. Thompson?
I'm not aware of that allegation, Your Honor. It's not on the alleged probation violation. I've seen Mr. Ackerman has strong ties to the community. He has a sister who lives here. He has a lot of extended family who lives here. I would ask the court to consider a lower bond, $1,000 or $5,000.
All right, looking at Mr. Ackerman's file, he was sentenced, it looks like back in August of 24. And his conviction at that time was possession of methamphetamine. Mr. Ackerman's been on probation since that time. Looking at the nature of the alleged violations presently include also similar charges of possession of methamphetamine. Based on that, the court has concerns regarding public safety, the fact that Mr. Ackerman used to be found in possession of methamphetamine even while on probation. Court finds calls for a cash or surety bond. I agree with the amount stated by Mr. Thompson. I think that'll ensure both public safety and Mr. Ackerman's appearance, and frankly, perhaps even his own safety. So the court will set bond in the amount of $10,000 cash or surety. If Mr. Ackerman's unable to post that bond, the court will make sure that hearing is set within 14 days. Mr. Thompson, if after consultation, put that out, just let the court know and do that. Consult with your client, but the court will make sure it's within 14 days for now. Mr. Thompson, anything further?
I just wanted Mr. Ackerman to verify it. Is that still your address and phone number if you're released?
Yes. I would own that. 99231. 231. 091.
Okay, that's your cell if you're.
That's my cell, yeah.
Okay, thank you. Nothing further for today's.
Thank you, Mr. Ackerman. You'll be notified of the date of that hearing. Okay.
I'll say, you know, back.
Is Mr. Bombgard present? Yes, okay. We'll go on the record in People versus Bombgard, case number 255453. Mr. Bombgard, if you come right up to the podium here, please. If I can have counsel put your appearances on.
Sierra Coke on behalf of the people.
Your Honor, for the record, Walter White was not on behalf of Mr. Bombgard. I'm sorry, I'm late, guys. A little bit of difficulty with my process.
Okay.
Well,
No problem. I got information about that, so. We're set for a status conference today. Mr. White, have there been any plea discussions between you and Ms. Hope?
Not since there was a preliminary hearing. It's my understanding people don't have any future proposals. They can correct me if I'm wrong. At this point, they're planning to have the trial by jury. We don't see any reason we couldn't combine it with the trial for the co-defendant. There are no conflicts or anything between the defenses that we think that appropriate severance. So it was a severance trial date. The one thing I would note is my client has got fairly severe prostate cancer. Just about every day. So probably accept himself that there might be for him at this point.
Can you say that last part?
Putting these a little farther out will enable him to get more of his treatments done. You're supposed to be there tomorrow and then treatments every day.
Okay, I got touch scans Wednesday. I've got a radiation mapping Thursday. Then they're gonna figure out how to treat the 28 35 treatments every day after that. We got doctor's appointment tomorrow because I'm just out of the hospital with vertigo and sinus. Anyways, it was just in the hospital, so.
Okay, it's gonna be about 60 to 90 days before I'll be able to get a trial date.
Sounds good to us.
Okay.
It worked out great. She be well established in treatment by then.
All right, so that's how we'll schedule it. We'll schedule it along with People versus Matthew. I indicated this previously with Mr. Matthew's counsel, Mr. White. Folks already heard this. If we do, it sounds like we do have a stipulation to consolidate for trial. So I'm going to ask all three attorneys to get together, prepare a stipulation order reflecting that the cases will be consolidated by agreement, and to submit that to the court for signing. And then Mr. White, you and your client will be sent notices of both the trial date, and we will have one final status conference prior to the trial date. That status conference will be the plea cutoff, so to the extent there are any additional plea discussions, that would be the last day to enter a plea prior to the trial. That would also be the motion cutoff, so motions can be filed at any time, but no later than the date or time of that final status conference.
Or if I can just clarify, the motions have to be heard by that date or they have to be filed by that date?
Filed and set for hearing no later than that date. So you can schedule it for that date or any time prior to that.
Thank you.
Mr. White, anything further I can address?
Nothing.
Nothing, thank you.
Okay, thank you. That's all. right, counsel, is that your client with you, Mr. Ozorio? Ms. Spack, are you able to hear me?
Yes, Judge, I apologize. I did not realize my computer was muted. Good afternoon, Judge.
Okay, thank you. How do I pronounce your last name? I'm not sure that was right, what I just said.
Judge, you were close. It is Spahich. It has a little accent above the C, so it's pronounced as a CH, Spahich.
Okay, great, thank you. And that's Mr. Ozorio there with you?
Yes, he is, Judge.
Okay, so we're on record in that file. This is case number 255456. Counsel and her client are appearing today by video by prior approval of the court. Ms. Koch is present here in the courtroom. This is the date and time set for a status conference in this file. Ms. Spach, can you tell me how you wanted to proceed today? Have you had any discussions with the prosecutor about a resolution?
Yes, Judge, at the district court level, I did have the discussions. There should be hopefully something in your file with respect to a plea. My client is ready to tender a plea of guilty to operating while intoxicated, third offense, with the understanding that the open intoxicant, open container in a vehicle will be dismissed. Upon his successful completion of a sobriety court program, that felony DUI will be amended to a 1-year misdemeanor DUI. My client has been accepted into the Waterford District Court program here in Oakland County. I am still attempting to get him into a Dearborn Heights District Court sobriety court program. However, I'm not having any luck thus far. Either way, Judge, my client will be entering a sobriety court program, and I'm hoping that he will be successful with it so that way he can earn that misdemeanor.
Thank you, Ms. Koch. Is that a correct statement of the plea offer?
It is.
Mr. Rosario, have you had an opportunity to speak with your attorney about this plea agreement?
Yes, sir.
Is that how you wanted to proceed today?
Yes.
Can you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Thank you. You can lower your hand. Mr. Rosario, are you currently on any kind of probation or parole?
No, sir.
You understand that by pleading guilty to operating while intoxicated, third offense, that if you were to fail to complete your probation or the sobriety court program, then it could subject you to the maximum possible penalty on that offense, which is up to 5 years and or a $5,000 fine. Do you understand that?
Yes, I do.
With that in mind, what is your plea to that charge today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
I do.
And you understand that you're giving up and waiving all of those rights, and you won't have them anymore, and that includes the right to have a trial.
Yes, I do. I understand.
Also, you don't have an automatic right to appeal the plea that you're making today. You can only appeal by leave. That means that you would have to ask for the Court of Appeals to hear your case. They could say no, and that would be the end of any appeal. Do you understand that?
I do.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we've discussed here on the record today?
No.
Is it your own free choice to plead guilty?
It is.
Are you pleading guilty because you are actually guilty of this crime?
Yes.
The information I have indicates that this happened on or about May 23rd of 2025. Is that the correct time frame?
Yes, sir.
On that date, had you been consuming alcohol?
Yeah, I was.
After you consumed alcohol, did you operate a motor vehicle on the I-75 business loop here in Crawford County?
I did.
At the time that you were operating that vehicle, was your blood alcohol level above a 0.08?
Yes, it was.
Did you have a blood or breath test to determine what that level was?
Yes.
Do you have any reason to doubt the accuracy of that test?
No.
Had you consumed enough alcohol that you believe that you were unable to safely and normally operate that vehicle?
I did. Yes.
All right, thank you. Ms. Koch, are you satisfied with the factual basis?
Yes.
Ms. Fodge, are you satisfied with the factual basis?
Yes, Judge.
Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Ms. Fodge?
No, Your Honor.
And Ms. Koch, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Ms. Fodge, are you satisfied?
Yes, Judge.
Mr. Ozorio, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. That hearing will be here in court in Crawford County as an in-person hearing. So you'll need to make arrangements to be here that day in person. Prior to that, somebody from the probation department will be in touch with you for a pre-sentence report. Just make sure you follow up with them when they contact you for that, okay?
Will do, sir, Your Honor.
Can we get his phone number, Judge?
Ms. Stahich, do you have a phone number where the probation department can contact your client?
Yes, I do, Judge.
Go ahead.
It is 313-268-6543. And Judge, I just had a really quick question. With respect to the sentencings, are those in person for both defendant and the attorney, or are there any exceptions that could be made with respect to that?
I generally expect counsel to be there with their clients.
Okay, fair enough.
If you have some kind of emergency or something comes up, I mean, that's.
No,
one
I
thing,
totally
but-
understand. It might not be a bad drive out there, Judge, just to kind of see the court, so it's okay.
All right. Okay. All right, thank you. That's all for today, and you're free to disconnect.
Perfect, Judge. Thank you for your time. Bye-bye.
Mr. Flagstad, were you ready with Mr.
We are ready.
This is case number 255455. If I could have counsel put your.
Judge Mike Flagstad, P number 79314 on behalf of Mr. Fenel.
Sierra Coke on behalf of the people.
Thank you. This is set for a status conference today. Mr. Flagstad, can you tell me where you were at with this case?
Yes, Your Honor. The goal is to get Mr. Fenel accepted into sobriety court. Otsego County Sobriety Court has a good amount of room. So that's what we're working on at the moment. There's one wrinkle that we're ironing out. But I'm optimistic he's got a fair shot at getting in.
How much time do you need to get that worked out?
Realistically, Judge, at least 30 days.
Okay. Ms. Koch, do you have any objection to adjournment to allow for that?
I would not object to one adjournment. We did make the offer on 7/24. So and this is his fourth drunk driving. There isn't an offer to drop it down to a second. So we'd ask that, I mean, he's either going to get in or he's not going to get in, but I don't know that that's going to delay whether we're going to have a trial or he's going to enter a plea.
Okay. So, Mr. Flagstad, the court will allow some time for you to try to make arrangements for Mr. Fenel, get him in there. Generally, that's a good outcome. So the court will send out notice of the date and time of that next hearing. It'll be in at least 30 days. And we'll set that as a plea slash status conference. I've said anything else I can address for your side?
Judge, we did take a shot at a draft MOU. I realize it's quite premature, but if the court wanted to review it and say, no, I want this different, we could offer that to the court today.
I think we could probably address that later. I
Premature.
don't think I've had problems with those in the past.
Given that it's Crawford to Otsego, I wouldn't expect a whole lot of problem there. And then Ms. Koch, I don't think I actually need you to sign the application, but I do have to check that you are on board. Is that okay?
Yeah, I usually just respond to the email when it comes in.
Very good.
All right, Mr. Fenel, just make sure that you stay in touch with your attorney so that you're ready to proceed at the next hearing, and make sure that you cooperate with anything that the sobriety court needs. Okay?
Thank you.
Thank you.
Thank you, Judge.
We have 2 hearings left at 3:45, so we'll take a short recess.
I think we have Mr. Townsend at 3:32 and Miss Waters, or are those in, never mind, those might be in district court. Okay, they're arraigned
Don't
now.
have them, but Mr. Vernon, were you ready with your clients?
Yeah.
Okay, Mr. Khan, if you come up to this.
We would ask that he be allowed to stay at the table. His medical conditions make it difficult for him to stand for periods of time.
Okay, that's fine.
Mr. Hamlin.
We'll go on the record in People versus Michael Khan, this is file number 255401. If I can have counsel for your appearance.
Sierra Coke on behalf of the people.
And we're on behalf of Mr. Khan, who's present, seated to my right. I can stand. Would you like me at the podium or am I okay here?
That's fine.
Okay.
Thank you, though. Okay, so this is the date and time set for sentencing in this matter. The record should reflect that it just received your notice from one of Mr. Khan's doctors. It appears he's got surgery scheduled for September 17th. Just so council's aware, I also received a summary report from Community Corrections outlining Mr. Khan's cooperation with that program. I also received an assessment from Catholic Human Services, which I had a chance to review today along with the PSI. Mr. Khan, did you have a chance to go through the PSI and talk to your attorney about that?
Yeah.
Mr. Vernon, are there any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the score?
No.
Ms. Coke, do the people have any additions, deletions, or corrections?
No, Your Honor.
Challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for Alex?
Your Honor, in terms of medical issues, I would defer to the court. This is a difficult case because of Mr. Khan's criminal history and the choices he's made. But the fact that he's already been through this. So in 2021, he was lodged. He got, I think, 90 days on 2 of the charges and 11 months on another charge. He was released on a medical tether in September 2020. This is from the PSI. He returned to jail October 7th, 2021. In the meantime, he got charged with absconding and home invasion. He had more medical issues. He was released again on tether in the 2021, and then he got convicted of home invasion, 3rd degree, had to go back to jail again. And the exact order of that is in the PSI. And then we have Mr. Khan here for OWI 3rd. And I think it's a true 4th. I realize he has medical issues that seem to stop him from being able to go to jail, but not stop him from being able to conduct criminal behavior and put himself and others at risk. So I really don't know what the right answer is. His labs came back at 0.20. It's a dangerous situation. And I don't know how somebody who has these type of medical conditions that repeatedly allow for him to be released from jail can continue to drive at that level of alcohol. So I would defer to the court as to what they think is appropriate based on his criminal history and medical history and how to best handle that. Thank you.
Great, thank you. Mr. Vernon, anything on behalf of the client?
So as you can see from what we just provided to you from the, and I'm going to get this name wrong, but Jagannathan neurosurgery. He has surgery scheduled for Wednesday of this week. They moved it up to the severity of the condition. That surgery identifies that they're going to be fusing the C4, 5, 6, and 7 vertebrae in his back. I don't think that, I would say that probably makes him not much of a flight risk. I think that the doctors are almost going to unanimously tell him that during his recovery period and probably going forward with all of his other medical issues, alcohol is not really an option for him. I suspect that would be very dangerous to his health and if not his life. So again, I think the court can be reasonably assured that that's not likely to happen. What we're asking the court to do is impose a period of incarceration, but hold that in abeyance. I don't think that the burdens associated with his medical should be placed on the jail trying to transport him or administering all the things that need to be done to manage his health. I would agree that some punishment is appropriate. I mean, it's a drunk driving there, it's a serious offense, and it does clearly endanger the public. I think we have to balance that against all of the other interests here, and I think that with the likelihood that he's not going to be allowed to drink by his doctors, the reality of the surgery that he has scheduled for this week, plus the upcoming additional surgeries he has, I don't see him in a position where he's going to be a risk to the community. I think the only thing he's going to be at risk of doing is harming himself. And I think that the supervision component of probation would be sufficient to accomplish what this court needs to do, which essentially is to ensure the safety of the public. I think the jail time being held in abeyance is certainly enough of a deterrent to ensure him not endangering anybody else. And there is a recommendation for some community service. I think when he's capable or available to do that, I think that's an appropriate way to resolve some of this. So we would ask the court to consider all of those things and craft a sentence that is appropriate to deal with his medical issues and frankly take those things into account.
All right, thank you. Mr. Khan, anything you wanted to say today?
I would like to mention something, and I'm sure nobody here realizes this, but when she said the absconding, I want you guys to understand that they gave me a piece of paper and let me out for 3 days. They told me to, let me out on the 22nd and said we could reconvene on the 25th of January, and gave me the paper and let me go to my Social Security appointment in my plain clothes by myself. So I went home thinking I had to come back to court the 3rd or 3 days later. And they said no, and they tried to get me for the absconding. So, but I had the paper to prove. So that wasn't really something that was my fault.
Okay. Anything else you wanted to say?
Just the fact that I'm planning on never drinking again. My plan when I get through all of this is actually to become a peer recovery coach. That's something I'd like to do.
All right. Well, like I said, I did read through all the information that I was provided with, including the assessments by Catholic Services, along with the PSI. I think, the attorneys are both right in terms of what they've discussed. You've had a lot of health problems that hasn't deterred you from continuing to commit crimes. So I don't know the extent to which these new procedures are going to stop you. People do all kinds of things that aren't in their best interest when they have problems with substances. And lots of people with lots of health problems that come in front of me who are using illicit substances and alcohol when they shouldn't be for health reasons. So I'm not sure that convinces me that you would stop. But I'm also satisfied that you have legitimate health concerns that would make it difficult for the jail to manage. And there is some indications both from your performance while you've been on bond, which has been positive. There are indications in that report from Catholic Human Services that are positive. So I think you're really at a point now where you're going to go one direction or the other based on your health and based on other factors. And so number one, I think the probation is absolutely appropriate. I think providing for some supervision to monitor what you're doing is absolutely appropriate and in the public interest for purposes of public safety. I think holding jail time in abeyance is also appropriate. And so I'm going to impose a fairly significant jail sentence, but hold that in abeyance. And if you violate your probation, if you continue to use substances, if you continue to do things that put other people in danger, number one, that'll be a signal to me that that's more important to you than managing your health and other things. Number two, it's also gonna put me in a position where your health starts to matter less than the safety and health of innocent people that you might encounter on the road. So to the extent that you violate your probation, your health and problems with your health is gonna cease being a reason for me to not put you in jail, instead of figure it out. So to the extent that you want to preserve your health, continue to get treatment for that, setting outside of a correctional facility, I would encourage you to follow the conditions of your probation, because there won't be any further reviews based on health issues. So the court is going to impose 6 months in the Crawford County Jail with credit for 2 days served. The court's going to hold that abeyance to be served at the discretion of the court. The court is going to put you on probation for a period of 2 years. The court's going to adopt this terms and conditions, all the terms and conditions listed in the report. And that includes restitution in the amount of $100 to police or OUIL testing, a crime victims assessment of $130, $325 in court costs, attorney fees of $350, $68 state costs, supervision fee of $30 per month while you're on probation. You will be required at some point during your probation to serve 30 days in jail regardless. That's a statutory mandatory provision. But if you comply with the terms of your probation, you would not have to serve the remaining 5 months. You do have the ability to seek an appeal of this sentence, and Mr. Vernon, if you could provide Mr. Khan with the acknowledgement of his appellate rights.
Thank you, Your Honor. I did go over those with you. You sign a receipt as provided to your clerk. One copy was provided to Ms. Cope, and the remaining 2 copies are in Mr. Khan's possession.
Judge, do I just, first the jail portion of that, do I just instruct him to report to jail when he's medically cleared? Or when I think he's medically cleared, maybe we could set it for, I don't know if we need to have a hearing.
I think that's a good suggestion, if you don't mind doing that. I'd like to see where things are at, how Mr. Khan's progressing with his probation. And so your second suggestion makes sense to me, is that you can set this for like a probation review hearing when he's medically cleared. Sure, go forward with that.
Okay.
I do not, I just would inform the court that I know I'm going to be a court appointed attorney on this matter, so if the court wants to be involved with that review, I would just be notified separately.
Your Honor, I do think that's appropriate. The mandatory 30 days can't be waived, but I understand because of his medical issues, we're holding it in advance. We have to let the probation and parole know about the mandatory 30 days, like what's happening with it. That's why he's asking about it.
Yeah. All right. Do you need to meet with Mr. Khan here today?
I do.
Okay, so Mr. Khan just needs Mr. Halabuk here after court today.
You.
All right, we'll go on the record in People versus Brett Douly. This is file number 255458. And is it Shoei, or how do you pronounce your name, sir? Counsel?
Mr. Shuey, Your Honor.
Mr. Shoei, okay, thank you. We have Mr. Shoei present with his client by Zoom, and Ms. Koch is present here in the courtroom. This is set as a status conference in this file today. Mr. Shoei, can you tell me the status of this case from your standpoint?
Yes, Your Honor, thank you. We were prepared to move forward with a plea today. However, I just was going through the file and I noticed we haven't received the blood results back yet. And I emailed Ms. Koch probably just a few minutes ago. I apologize for the late notice on that. I just was going through it and I don't know if she has those results. I'd rather not plead my client to anything without having that blood work back, especially since an OWI is involved in all of this. So if she has those, I guess we would be ready to move forward, but if she doesn't quite yet, then I guess I would ask for a little bit more time.
So,
I do not see, I wasn't aware of this issue till literally right now. I do not have lab reports in my file. There was a blood draw.
all right, so Mr. Shoei, I think it's a reasonable basis for an adjournment in this case, so that you can have that information, have an opportunity to go through that and discuss that with your client. So we'll set this for another status conference / plea hearing. I mean, it sounds like, I mean, are you fairly confident this is going to resolve by plea, Mr. Shoei?
Yes, of course, Your Honor. If it's, after talking to Mr. Douly, I think that this would come to a resolution if the blood work came back where it proved that he was intoxicated. That's just, I just don't want to commit malpractice by having him plead to something that without having that result back. So the other thing I would ask, Your Honor, is if the next hearing also, we would request Zoom if possible. Mr. Douly lives in Maine. I'm in Grand Rapids. However, of course, I would be willing to make that drive if I had to, and I know Mr. Douly would too. But the next hearing, whatever that would be, if we could request that to be Zoom also. We understand that if there's ever any sentencing or trial, we would definitely have to be there in person. We both understand that. And I know that Mr. Douly is abiding by all terms of his bond conditions. So we would respectfully ask for that, Your Honor.
Okay. Yep, I don't have a problem. So we'll just put it on the record. The next hearing, which I'll call a plea hearing / status conference, will be by Zoom. So Mr. Douly, just make sure that you sign in just as you've done here today. And Mr. Shuey took the words right out of my mouth, which is if we do have a plea at the next hearing, then following that, court would set it for sentencing, and that will be an in-person hearing for both of you. So it sounds like you're already ahead of the game on that, if we get to that point. But otherwise, we'll proceed in about 30 days with a plea / status conference by Zoom. Mr. Shuey, anything else that we can address for your side while we're on the record today?
I don't think so, Your Honor. I know Mr. Douly, he works on a ship. I think even with a Zoom, but he might have to speak to this, would still be able to meet that requirement. I know he has a schedule where he goes out on a ship for a while and then he comes back in. So I'm not sure if there's a schedule that he would request respectfully. And again, I know that he knows he's got to address this whenever this court wants him to address it, but he's muted right now, so I don't know if he can unmute himself and let us know.
Yep, I have my schedule for work. I could pull it up if you would like.
Well, I mean, unfortunately, I mean, Mr. Shuey, I can't schedule court around Mr. Dooley's work schedule, so we'll have the date set when it's set, and Mr. Douly will just have to make arrangements to be able to be present by Zoom for that hearing, okay?
Yes, Your Honor.
All right, aside from that, Mr. Shuey, anything else we can address for your side?
Nothing further, Your Honor.
Okay, Ms. Koch?
Nothing, Your Honor.
All right, thank you. You're both free to disconnect at this time.
All right, thank you, Your Honor.
And that concludes our afternoon docket. The court will be in recess.
Sarah, if you want to make a note, apparently Arizona didn't realize there was a time difference.